I imagine you and I are similar in many ways. When creating my editorial calendar, I try to craft a broader narrative of the design and architecture industry. I view this show as a time capsule, being both created and consumed in real time. But if you go back and listen to episodes from 2013, when this podcast was started until now, you will discover an illustrative exposition that both narrates in real time and looking forward to demonstrate where the industry is going by examining where we are and where we've been. It's a futuristic approach to the built environment. To be transparent with you, that is the part I enjoy the most. Every now and then, like the impact of a meteor, something happens to make us all think about the industry as we know it. As we approach the work these days, it feels like we are experiencing an unending barrage of meteor strikes, which is turning our industry upside down and has been. And I'm trying to remember when it started. I would say the pandemic is when it started in earnest for me and when I really started noticing it. And believe it or not, I'm not even talking about tariffs, government chaos, wildfires, or the supply chain. We will be reviewing and continuing to talk about all of these, but not today. In 2018, you might have heard a conversation I published from the LA Design Festival on the topic of intellectual property rights, IP law, and how it was affecting the industry. In the following episode, I will be introducing you. Actually, no, that's not right. In this episode, I will be introducing you to Andrew McBride, partner at Adams and Reese, and Carter Pope, associate at Adams and Reese. I found Andrew and Carter while on a journey of exploration. In other words, I was researching. There is a case moving its way through the legal system called Aaron and Samantha Judge v. Drew Designs, LLC. And yes, it's that Aaron Judge. This is a case about a design relationship gone wrong, rife with communication issues, contract issues, and a litany of other things that make for a messy professional relationship that can, and in this case, winds up in the courts. McBride and Pope authored an article online called Hidden Ball Trick. Yankees Aaron Judge case involving deception carries lessons for contractors. I've added a link in the show notes, and I highly recommend this for contractors, architects, and designers. Read it. Read and heed. I'm telling you. The following conversation covers, with Carter and Pope, covers a number of issues that led to both parties winding up in court, as you're going to hear. Much, if not all of this, gosh, it could have been so easily avoided. And I think that's the case in most cases. In addition to this case, we also explore the Judd Foundation v. Clements Design, Inc., a case that will surely affect the future of dupes, as well as another case winding its way through the courts like a medieval knight moving through the digestive tract of a money-guzzling dragon. But that's how this feels to me. Gifford v. Shield. Perhaps the metaphor is a bit too graphic. I'll rethink that one, but it fits. The law is a complicated knot of ideas, and it seems to me that the best way to avoid a battle and legal entanglements is to do good business in the first place. And when disagreements come up, and they always do, you work hard to find common ground and squash it. And this is why you will hear the whole conversation with Andrew McBride and Carter Pope of Adams and Reese right after this. Oh, and by the way, before I get to the right after this part, this being an episode about legal issues, as in all the issues we talk about on the show, but this one in particular, because we are talking about legal issues, please Do not take anything that you hear on this episode as legal advice, because it's not. They don't represent you. They're not your lawyers. And nothing that's said on this episode is applicable to you or your case unless you engage with them legally and contractually in an attorney-client relationship. Okay, that's the disclaimer. There will be more right after this. At the highest level of design, the absolute best specifying designers, architects, landscape designers are all highly focused on the technology and performance of products and materials today. You have to, because the products you specify for your projects have to perform and they have to last. That's one of the reasons why I am so proud to be working with TimberTech. Their focus on the technical renaissance of synthetic decking is literally changing the conversation about innovation and performance. It pulls focus on three priorities homeowners have and expect from the products their designers and architects specify for their luxury projects. 1. Aesthetics must match the overall design and fit visually. 2. Durability and maintenance. I've told you about my board flipping stories from my own wood decks. Clients not only want beauty, but they want ease of use, and they want it to last for decades. 3. Sustainably made. Clients are more conscious of the environment now, and they want the same of their materials. TimberTech hits each one of these elements with a product that not only meets expectations, they exceed them. TimberTech makes a synthetic decking that looks just like wood, color and embossed wood grain for a natural appearance. Their composite decking is technologically superior, as it has been created to last for decades, and it's manufactured with up to 85% recycled material. Their advanced PVC, vintage, and landmark collections have a Class A flame spread rating, making these products an amazing choice for wildfire-prone areas, which unfortunately continues to grow on the risk map. Check the show notes for more information about this and to find the nearest showroom or lumberyard where you can find TimberTech, or you can check them out directly, timbertech.com. First of all, thank you both for coming on. I am so used to talking with designers, architects, and those in the trade, but I have had attorneys on before, and I'm captivated and just fascinated by what you do. And by the way, it is not at all dissimilar to design and architecture, because when you're creating a case, when you're crafting a case, when you're creating the story, you're kind of building from a foundation. With that, if that's not a primer enough, would you mind, Andrew, you first, and then Carter, would you guys sort of introduce yourselves and just sort of talk about what you do and why you do it?
Thanks, Josh. Happy to be here. Appreciate you reaching out. Happy to speak today. Andrew McBride. I'm an attorney with the Adams and Reese law firm here in Tampa, Florida. I'm a partner. Spent my entire career with this law firm. I consider myself a business problems attorney. When clients have problems with their business, whether it's contract, whether it's lawsuits, whether it's real estate, corporate, you name it, I try to find cost-effective solutions and really drill down to the heart of the issue and try to give them a holistic solution, to solve whatever it is that is causing them stress, keeping them up at night, and sort of taking that stress off their shoulders and handling that myself. That way they can go back to doing what they do, which is to be successful in their business. So happy to speak to you today.
Yeah, and thanks, Josh. Carter Pope. I am also based in the Tampa office of Adams and Reese. I work mostly in construction law. That tends to be litigation, although I do a lot on the corporate and what you would say transaction side of it. I think you ask why I do what I do. In what feels like a past life, I worked for a pretty big construction developer here in Florida, and I mean, I appreciated the experience. I really enjoyed my time there, but I felt like my cause, my purpose was better served in really helping solve issues in the same way that Andrew spoke to earlier. In that, I really see myself in my role as handling what I do, so that the business people who ultimately make the world go round can do what they do best.
I reached out to you, and I'm incredibly thankful that you both granted me an audience to do this. There is a case that we've discussed previously that is floating around the industry right now. It's the judges versus Drew Designs. It's a Florida case, so it's right in your backyard. Florida and New York, I think, but it certainly addresses your backyard as well. I have said this before on the show, and I think it's true, that our industry takes legal issues fairly lightly. And I think most industries do. And I think sort of setting the macro expectation, it doesn't matter how good your contracts are, you can be sued for anything, for any reason, at any time. True?
100% true. Unfortunately, the threat of lawsuits, the threat of litigation or claims is always there. It just takes $400 and an imagination to file a lawsuit in the state of Florida and in this country. So it's a reality that businesses face all up and down the country.
And while we were talking, we were sharing some ideas offline, just kind of how contracts work, and especially for an industry like design. Now, I had mentioned before, personal opinion, I think the architecture side is far more buttoned up than the design side. And Carter, you could probably speak to the contracts on the construction side as well, having done those in the past too. I think those are fairly tighter as well. But as we look at this Judge v. Drew Designs, and I know that you've looked over this, what's your initial takeaway?
Yeah, happy to answer that. I guess I should preface this to say neither Carter nor myself are attorneys in the case. It's not our case. We don't represent either the plaintiff or the defendant. We're simply viewing this case. It's all publicly available through the court system. We've reviewed the pleadings, and I think this case illustrates important principles that listeners on this podcast, design professionals, should take into account when looking at their contract arrangements and when they look into going into business. This case is very fascinating, and it's heating up, and I think it is a major story. It's going to continue to be a major story. Carter and I also are both licensed in the state of Florida and practice here in the state of Florida. Obviously, anything we say today is not per se legal advice. We're just talking general principles. And of course, we don't represent anybody who's listening, and there's no attorney-client relationship, but we're happy to be here and answer some questions and to kind of give our opinions on the best ways to go about contracting to avoid these types of disputes. This case, was filed recently in the last couple of months. And since that time, there's now counterclaims pending. And I think it's one that's going to have to work its way through the court system, and the evidence is going to have to come out. But it definitely is a high stakes case with serious allegations of malfeasance and wrongdoing, really going both ways, but particularly towards the defendant. And I think that there's a lot to learn from this case and best practices. The central idea is before you go into business with a potential client, with a potential customer, before you accept money or begin work on a project, you need to think very carefully about what it is you're proposing to do, how much it's going to cost, how you're going to price it, what the type of communications are going to look like. And to the extent there's known unknowns, things that could go awry during the course of the project, during the course of construction, during the course of design services, how do you allocate risks and responsibilities? Because I think one of the themes of this case is feeling like something was discovered that wasn't on the up and up, right? That a deal was presented, but the actual deal was different. And the judges, Aaron Judge and his wife, of course, is a very famous baseball player, one of the best in the game, are alleging in this case serious allegations that they were told they'd pay one thing and they ended up having to pay another. And it was done in a manner that wasn't, transparent and clear. And look, these are just the allegations in the case. Obviously, we're not the judge in the case. We're not in the case. It's going to play out in deposition testimony, potential trial. We'll see how it shakes out at the end of the day. But the allegations are serious. And I do think it's important, just as a central concept, which I think we're going to be talking about a lot today, Josh, that work should be done on the front end. Critical thinking should take place on the front end. And it's not really sufficient to just use a form contract off the shelf that's pretty thin, pretty light, doesn't really address these types of issues, because life would tell us that problems will occur, that unpredictable outcomes will occur. And the hope is to address a lot of that in the front end, so there aren't disagreements and fights, and you don't find yourself in court, which is becoming more and more common in today's day and age.
It's interesting too, and by the way, I totally appreciate that, Andrew, because coming from the broadcast industry, as you started, that is what we call in the biz the disclaimer. So I'm going to give you my opinion. Don't sue me. And I think it galvanizes the point. And the point is, and I've read the complaint too. You and I discussed it the other day. It appears that the judges brought receipts. That and I mean, that's the nature of a complaint, right? Is they're going to try to put their best foot forward to make sure that the case is allowed to continue and doesn't get thrown out at the start. And understanding that neither you nor Carter nor your firm are participants or parties to this case, you haven't worked on it, but you wrote something that I read, which initially is what I called you about, because I thought it was clear, it was concise, and it kind of laid out the story. If you are a creative of any kind, if you are a designer, architect, if you're a builder, a design build firm, you want to make sure, because of the amount of money that you're dealing with in a lot of these cases, because it's so personal, especially when you're working on a residential project, it's someone's home, it's where their families are. If you tell somebody one thing and then receipts come out to the contrary, it breaks a fundamental trust. And an agreement is meant to establish that trust in a format that everyone is comfortable with. That's how I see it. But also because creating a contract can be tenuous, it can be expensive dealing with a firm. Going with a boilerplate option could be a simple alternative. Where's the happy medium? If you operate a design firm and you have the same, here's what you charge, here's how you charge, here's why you charge what you charge for this, that, and the other thing. If you're getting a trade discount, it should be reflected. It doesn't necessarily have to be percentages, but that third-party relationship does exist. Where would you suggest, if you were meeting with a client for the first time who was in the design industry and they wanted something that could survive a challenge, but could also be altered on a client-by-client basis so as to minimize cost, where would you start?
It's a great question. And I agree with you. I don't think it's a situation where, if you're a busy designer with lots of clients and lots of new matters, you need a bespoke contract for each new engagement that the lawyers vet, that requires significant attorney time to draft or to revise. I think that if work is done on one type of matter and a contract is drafted and reviewed and thought about critically, and then in the future there's other matters that are very similar in scope, similar in what the ask is, what you're being asked to do, and the type of payments that will be made under that contract, I think that base contract can then be modified in very slight ways, which wouldn't require full legal review, wouldn't require turning it over to the attorneys and giving them a week to revise it. I think certainly clients that we deal with might come to us for a base contract, which would be better than the contract they've used in the past, that has more terms, more detail, more explanations, and work can be done to prepare that. And then that contract can probably be used for many, if not most, matters that company would use for the foreseeable future, that they would have need for the foreseeable future. But with each job, with each new assignment, I think what the party should be thinking is, what's different about this scenario? What has changed in the world? For example, tariffs. Tariffs are in the news nowadays. It seems to be a big issue that companies across the country, across the world are facing. If you had a contract that was done 2 years ago, before the threat of tariffs became so prominent, I think it'd be worth looking at it now to see if, for example, you're importing stone from Italy and now the price is going to double because of tariffs, maybe you account for that in your contract, whereas you didn't back in 2022, but now in 2025, you are going to do that. So I think as circumstances change, there's a need to revisit the form contract or the base template contract that you would use for different jobs. And I do think it's valuable for businesses that are doing any type of volume, that are handling sophisticated matters, that are working on people's homes and people's property, where it's very personal to them. I think in that scenario, the risk of a claim, the risk of litigation or threats of litigation are higher because of the personal aspect of it. And I think it's a situation where an ounce of prevention can be worth a pound of cure, and putting the time in up front to actually get some legal advice to see if you are checking all the boxes you want to check and anticipating all the needs and issues that you have. And I would encourage the listeners on this podcast, and really anyone in the design space who does business, with significant amounts of money, to invest in a relationship with an attorney who is licensed in your jurisdiction, wherever you may be, who you trust, who you could have a relationship with and go to with questions as they arise, and to get that type of consult on the front end that you need. Because it's so common to see contracts that are just full of holes, full of ambiguities, don't answer basic questions. Without casting aspersions, I do think that the contract documents attached to the complaint in this case and the counterclaim in this case, the Aaron Judge case, probably could have addressed some of the issues that are being raised in this litigation and didn't. And I think that omission on certain key terms really is fuel to the fire to make this litigation more hostile, more expensive, more risky than it otherwise would be.
Hey, Carter, in your experience working with the construction industry, working in the construction industry, now were you working as an attorney for a contractor?
No, I was on the contractor side, actually, like an owner developer that does a lot of in-house. Very similar to Miss Drew in that I would consider my role more like a project manager. I was not a licensed contractor, but I had the phone numbers and the pleasure most of the time to be the hands-on guy representing our big owner in those contract discussions, in those city discussions, making sure the projects move forward.
I love it. Okay. So what did you take away from that experience that you utilize now? And not particulars, not from any specific instance, but one of the things that I thought was interesting, and I'm just going to paraphrase this because the Judge Drew complaint is very long and there's a lot of detail there. But one of the things that caught my eye, and if I'm wrong on this, please correct me, but one of the things that I thought was interesting was the designer's relationship with the contractor. And it looked like there was a third-party relationship between the design firm and the contractor that was not made public to the client, which I think caused a little bit of trouble there. What did you glean from your experience as in your role as a project manager, and how might you suggest that designers insulate themselves and protect themselves from that type of blowback?
Yeah, sure. I think the point the point you're making and really capturing out of the complaint is that Miss Drew, from the allegations of the amended complaint, agreed to kind of be an owner's rep or an owner's representative in a way that all the invoices, all the communications were, again, in the complaint, we're told, supposed to go through her. I think a contract, in most instances, should really capture the scope of work. And I mean that both from the standpoint of what's going to happen on the ground, what walls are we changing, what furniture are we buying, but also from a how do I represent you? Because it's not uncommon for you to see engineering, architect, interior designs agree in their standard contracts to be an owner representative and to negotiate with contractor. And in a lot of instances, that makes a lot of sense because the contractor might say, well, if we swap out this material, it doesn't change the overall appearance, but it can, result in cost savings. Can you update the design to accommodate this? And that's really valuable for an owner, for a customer, to have an owner's representative that serves in that capacity. But in some instances where the interior designer is also passing along those costs, and in this instance where all the costs were coming through Drew and then to the owners, you take on the potential concern where an owner thinks not only are they representing me in design issues, but they're also being fiscally responsible for the pocketbook of the project. I think that the recommendations, I think the recommendation there is always going to be make sure that your scope of work in your contract is very tight. Make sure that your pricing is very tight and really reflects the scope of work. And to your point, I think earlier, and a point Andrew made, we hear constantly when we are asked to prepare a contract. I need the simple version that's going to keep me out of everything, or it's going to be perfect. I'm not going to have to come back to you. And in a lot of instances, we can get you 80% of the way there, 90% of the way there with some kind of form-based template. But when you have these unique projects come along, and it looks like Miss Drew, had a unique opportunity to be managing two projects simultaneously in two different states. It kind of screams that maybe you want to take a little extra care in this instance to have that contract or something vetted. And I will say, there are instances where the contracts I work on are fairly standard. I give it to the client, and I don't see different iterations. I have really big clients who have hundreds of projects going on at any given time. And in those instances, they ask for not only a really bespoke agreement, but we even prepare what we refer to internally as playbooks, where it gives you negotiation points, and it gives you, if the owner makes this complaint, swap out this provision. And so we actually, we have the ability, once we understand your business, once we have those conversations with a client, to make sure that we can really fill the need that the contract needs to fill for your business. So
you are listening to my conversation with Andrew McBride and Carter Pope of Adams and Reese. We'll be right back. The most important word in the design industry today is service. Product, incredibly important. Price, important. Selection, incredibly important. But stellar service is the premier idea that can make all the difference in the success of any project. This is how design professionals like you demand great service for your projects. And you get your favorite brands in one place with expert, knowledgeable, and non-commissioned professionals to help you specify the right product for each of your projects and get the best price. Non-commissioned, that is incredibly important. And at Pacific Sales Kitchen and Home, a Best Buy company, that means their only incentive is your satisfaction. Pacific Sales Kitchen and Home, a Best Buy company, has just that with over 60 years of service in Southern California. Pacific Sales is your destination for exploration, advice, inspiration, all the best brands, great prices, the best in the industry when it comes to service, and you know it's reliable. You know that you are going to get predictable results, reliable results every time. And now you have the Pacific Sales Kitchen and Home team to help you with their Pro Rewards program, which is a trade program unlike any you've ever experienced before. Earn 3% in Best Buy e-gift cards or 2.5% in a reward check for every qualified and delivered sale, in addition to special trade pricing, exclusive offers, access to exclusive special events, and so much more that I can't even begin to try and list it all here. And here's the cherry on top. Access to exclusive builder trade incentives from top brands and the stellar service you deserve from a company that has been serving the industry for over 60 years. Now, terms and conditions apply to the Pro Rewards program and builder trade incentives. So visit a Pacific Sales expert at a showroom today for full details and learn how you can unlock additional savings and benefits. Don't miss out on the opportunity to work with the best of the best. Visit Pacific Sales Kitchen and Home today and elevate your projects to new heights. The Design Hardware Showroom is a space where specifiers can go and find an incredible selection of high-end faucets, luxury tile, natural stone, wood floors, and bespoke hardware, and so much more. Select products are presented in a holistic manner, strategically arranged to stimulate creativity and transition your vision from the conceptual stage to a fully realized space. You will find everything you're looking for, even the products by brands you didn't know you didn't know. Surprise and delight. Am I right? All under one roof on 3rd Street in Los Angeles, just up the street from the Grove. Conveniently located, free parking available. Stop by to find inspiration, collect samples, get expert advice, and tackle everything on your specification list all in one place. Visit them online at designhardware.com, at Design Hardware and Flooring on the socials, or in the real world, 6053 West 3rd Street in Los Angeles. Those are great points. You know, at the end of the day, like we're talking about, $400 and a willingness to fight, and you can sue anyone for anything in the state of Florida. It doesn't mean that it's not going to be frivolous. It doesn't mean it's not going to be kicked out. It doesn't mean anything, but it gives you the ability to get in the ring with somebody else. And I feel like any issue that winds up in a legal situation, in a legal conflict, will arise from a lack of communication. Is that a fair statement?
I think that's often the case, where people feel like something's being hidden from them, or they feel like they're being taken advantage of. That sort of triggers that desire to fight and vindicate their rights and seek justice. It's called the justice system. And if they feel like they've been treated unjustly, they're that much more likely to go run off to the courthouse and fight it out. And that is the allegations in this judge case, that essentially the judges thought they were agreeing to one thing, when in fact other things were happening without their knowledge. That invoices were being passed on to them, allegedly. That includes upcharges when they were told prior, numerous text messages that are all incorporated in the lawsuit itself, indicating that that wouldn't occur, and then they find out it did. Being told that a piece of furniture they have to pay $30,000 for it, when they find out maybe it only costs $20,000. Seems like a lot for a couch, but I understand that can be the price of a nice sofa in a home like this, and that will really incite them to take action. That will cause really any reasonable person to feel like something is wrong here, and the truth is, courts will look at things like text messages. A contract can say one thing, but if the contract is contradicted by the actions of the party, and somebody is led to believe a certain thing, the contract won't necessarily insulate you from liability for that either. Courts are able to, and often do, look at events and circumstances arising outside of the contract itself. And that's a big part of this lawsuit, where you have a contract that is short, kind of vague, not a lot of detail, doesn't go into all of this. The copy attached to the complaint isn't even signed. And then you have a number of allegations of specific statements and representations and promises and text messages that create a totally different picture. And that's really what these claims are based upon, is the actions of the parties during the course of the work being done.
And
Sorry, Carter, go ahead.
well, and I was just going to say, I mean, if I could build off of that, this is the Drew case is an instance where there's extreme allegations being made of fraud and bad actors, but it's not uncommon for a contractor, an architect, a designer to enter into an agreement in one set of circumstances, and then the world change on the flip of a dime. And we're coming out of a world that still is post-COVID, where COVID era construction litigation is still taking place. Here, at least in Florida, we are dealing with unprecedented storms over the last couple of years, and those impact not only the construction that was going on at the time of those disasters, but also surge pricing, where if you need a contractor in the state, it's now 2 or 3 times as much as it would have been prior to the storms. And I know in your neck of the woods, there's unprecedented, fires happening, in which case something similar will likely happen where instead of it was easy to find a contractor, contractors may have even been looking for work and offering discounts. Now everyone is going to be booked. It's going to be impossible to find materials timely. It's going to be impossible to find labor timely. Um, so I mean, it's a good time, I guess, and that's not even talking about the issues related to tariffs and other international trades that Andrew mentioned earlier. So it's definitely a good time to, if if any of those things have impacted your business or may impact your business, to take the extra step and make sure your contract really speaks to the potential that those events can have on the pricing and on the scope and all the other things we've discussed.
It's interesting, and Andrew, I didn't mean to laugh, but when you said, that $30,000 seems like a lot for a sofa, I think that perhaps you might not have utilized the services of a designer in the near future or in the recent past, because man, things are getting expensive. They really are, and I think that kind of speaks to the point. I think that, in my experience, and I can tell you this, I do what I do. I cover the industry that I cover because I absolutely love what designers and architects and design build and contracting firms do. I think what they do for people, especially on the residential side, is just extraordinary. They make the lives of those they serve better. Now, architecture and construction, I think, and I said this before, this is personal opinion, but I think they're more buttoned up because they kind of have to be, because decoration is not, in most cases, going to, in any cases that I know of, is not going to lead to a structure falling on somebody, or something not being suitable as a residence or as a building. So I think it's not that it's more important, it's just that it's a higher priority. With designers, some of the challenges that designers have are really interesting. You can ask 10 different designers what their business model is and how they charge, and you'll get 9 or 10 different answers because there are different ways to make money in the industry. The problem is they also have to account for things kind of like, Carter, what you were saying, in the case of surge pricing or supply chain disruptions or tariffs, during the pandemic, it was really interesting when supply chain was at its worst, right? You would have a sofa, call it a $30,000 sofa, being specified on a project, and then that sofa would be discontinued for whatever reason, or it just couldn't get there, or wasn't available, or the fabric or the stuffing wasn't available, or the wood material or the aluminum wasn't available, whatever it was, something would be discontinued. Then the designer has to go back to the client and respecify. Well, if you're respecifying, that is going to change the nature of the budget. It just is. If you were nowadays, where you've got appliances, and Carter, you're talking about tariffs on raw materials that lead to higher prices of things. So appliances are all going to cost more. Earlier this year, designers got depending on the manufacturer, got a 6 to 13% notification of price increases in 30 days. Well, if you've got a budget that's already been set and worked into a contract, it's going to change things. And contracts weren't meant to change that rapidly. So you talk about how courts will look at text messages and emails. How do you take that type of communication and make it applicable to a signed contract when things are changing so fast?
Or you want to address that?
Sure. So I hate to give you a lawyer answer, Josh, but it does depend. Most let's say good to great contracts will have something like a merger clause, which will say all other communications outside the contract are irrelevant. But I will tell you, at least in Florida, and I know in most other states, if the parties have demonstrated what we in the legal biz would call a course of dealing, or really, I think you can just say a conduct, if the party's actions demonstrate that, hey, we were willing to, despite our contract saying nothing other than what the contract says, we flexed on the price here, we agreed to an extension at a different time. All those things create a course of dealing where a court can say, well, it looks like both sides were willing to modify the contract despite, written and signed amendments. So I'm going to recognize that the parties have that conduct, and I'm going to look at other text messages, other actions within that context of, you guys look like you were willing to make accommodations in the past. How come this isn't also just another instance where an accommodation was made? So that goes less to the original contract and more to the fact that I repeatedly, insistently, ask my clients, contractors, designers, architects, if you're going to make a change, whether you're calling it a modification or a change order or an extra or a favor. I hear favor all the time. Make sure that there's some kind of writing, preferably signed by both parties, that puts a limit on what that change favor really is. Otherwise, you risk what was just a one-time favor becoming the foundation for other things that should be that should modify the contract, not being allowed to by a court because they say, well, you have a history of conduct in which you guys were willing to play loosey-goosey outside of the contract.
It's interesting. So what I'm hearing, and I'm going to turn this into a question to make sure that I understand it, because I think it's a really interesting point. The idea of the change order, for reef specification and design, or a change order in architecture and construction, I think one of the most challenging aspects for clients, and in this case, the clients are the designers who are going to an attorney to protect their interests as it relates to their relationship with their clients. I think in the past, when anyone hears the words change order, it incites this thought. It induces the thought of, it's going to cost more. Now I have to pay more. Every time there's a change order, you have to pay for it. And it almost feels like the idea of a change order, assuming that there's no cost incurred by both parties, it would almost be better if a change order was not charged for. And I know why professionals have change orders in their contracts, but it almost feels like a change order is something that would be instituted to protect as opposed to be a revenue driver.
I think that's right. We see change orders that in the best circumstances relate not just to pricing adjustments, but they also reflect when the scope of work changes in, whether that is I'm no longer doing room A and B, I'm just doing, handling room A, or whether that is, in the Drew case, it's been alleged that the original home was supposed to be 6,800 square feet, and then the judges changed their design, and the square footage of the home is now over 8,000 square feet. So, if that is true, it probably should have been captured by a change order. In that instance, you have the basis to request an increase in cost or a revenue driver. But I think in the best instances, change orders are to just reflect the current state of the contract and of the project itself.
I'll chime in briefly as well. Change orders, and can be a dirty word depending on who's saying it. Obviously, clients don't like them, feel like something they're being asked to pay that should have been included originally. But of course, there's unknowns when you enter a contract. You enter a contract in March 2025. The work will get done over summer and fall 2025. Who knows what the world will look like? Who knows what things will cost? And partly depends on the type of the contract. Obviously, there's fixed price contracts where everything's inclusive, a certain number. That puts some of the risk on the contractor, on the designer, in case of price increases or changes to the complexity of what's being asked to be done. Cost plus contracts provide more flexibility to the design professional who's offering their services because, for example, a certain sofa is going to be purchased. It costs $15,000 or $20,000 today. Maybe by the time it's ultimately purchased in September of 2025, the price will jump up to 30. You might document that with a change order that the estimate of the contract of 15 or 20 is now actually 30 and it's signed off on. It provides clear communications, a clear paper trail. So if there ever is a court case, you have the receipts, you have the document to show that there was transparency, there was communication, and there was acknowledgement. Courts will look at contracts and contractual relationships in their totality, not just the initial contract, but as it's a fluid situation with things changing rapidly, potentially changing rapidly, what happened subsequent to the initial contract. And I think a signed change order, signed acknowledgement of some difference from how it is now versus how it was when we drew it up is so important and so critical and seems to be lacking in this case, which I think is really adding fuel to the fire in these allegations.
It feels to me like one of the stickiest parts of this particular case and the allegations made are the third party relationship. Insofar as you have a designer who may have other sources of revenue in the form of a trade discount. So if they charge the client the retail, but they get retail minus trade discount, and so they're paying, it's not necessarily a wholesale, but they're certainly paying less than the retail, and it's not specifically outlined in a contract, almost because it can't be, because you don't always know what that trade showroom relationship is going to be like. You can tell if it's someone that you've been working with for a long time, but in the course of design, especially when it comes to respecification or something that causes a redirect, you may be working with a new vendor that will have some other kind of trade program with a benefit to the designer for specifying their product over another. If you were speaking to a client in design and working on a contract, how would you suggest that a designer communicate these relationships to you and that those relationships be preserved and protected under an agreement?
I can definitely speak to that, Josh, which to Andrew's point earlier, the way that ultimately ends up in your contract and the way that you disclose those benefits and relationships to a customer likely go back to the contract you have. And what I mean is if we're operating in a scenario where it's a fixed price contract, I don't think there's much reason that a design professional would have to do that other than selling their business, because they're saying you're going to pay me X amount. For X amount, I'm going to provide you the product and service. What savings I make, good or bad on my end, are the risk that I'm willing to take. But if you're in the universe where you have a cost plus contract, I think I think there's a bigger reason why you'd want to disclose those, but mainly so that the client sees the pass through cost to you. But I will say that doesn't mean that you can't still benefit from that relationship. Still sell your business because you've clearly done a good job. It's why you have these contacts, it's why you have these benefits. But in addition, we have that I see less in design professional and architect contracts, but see a lot in the contractor side of contracts, what are called savings clauses. And if that's a foreign term, it essentially is a negotiated clause with the ultimate end user customer where you say, if I'm able to save you money from the original price, I get a portion of that. So for example, in like a typical cost plus contract, let's say it's a $50,000 job and you're going to get 5% interest or sorry, 5% profit, 10% overhead. If you have a savings or if there's a savings event that moves your price down $1,000, so now you have $40,000 value, you don't get to keep that because you've agreed them to bill them the cost plus your 15%. But if you do have a savings clause, and again, we routinely insert these in any cost plus kind of relationship when we don't see them, a savings clause would allow you to keep 50% of that discount. So then the contractor and the owner, or the design professional and the owner, both benefit because they get a $500 discount because you're able to move the price down, and you get $500 in additional profit because of that relationship. I will also say, meaning you, the clients and listeners, how good your trade relationships are. And if they're really good and really competitive, you can move that from a 50-50 split with the owner to a 75-25 split. You can also decrease it if you're new to the market and you're still building up your industry relations. You maybe need to build that portfolio to have a 25% savings clauses or even a 10% savings clause. Ultimately, your contract can help you both market that benefit and then also get the advantage of and share that advantage with an owner of those relationships that are really difficult to build in a lot of instances. So
I think that's outstanding, and thank you for that. I think that seems to be isn't it interesting? That's what it comes down to as well, making reasonable, rational accommodations. I don't think contracts need to be volumes and volumes of text. It can be streamlined, and I think that that's important. And it's so funny too. This conversation that we're having here, as I look at the timer, it is just flying. And I think that this is incredibly valuable. One thing I would ask you is, in dealing with new clients, let me back up. I think one of the reasons that anyone doesn't go to an attorney to get a contract is because of the cost associated with it. You're doing the math in your head. It's like, well, if I'm working on X and now I have to deduct Y in legal costs, then Z is my profit, and I don't want to spend that money on something. But spending that money could be the difference between you making money in a year or losing catastrophically because your contract wasn't solid. When you are working with a new client for the first time, or even if it's not your own client, if you were giving advice to somebody you're going to sit with an attorney to have a template, not necessarily a specific contract for a specific client, but a template worked out. And Carter, by the way, I love that idea of kind of like the plug and play of different provisions, like if then scenarios, if this happens, then you plug in that one. I think that's brilliant. How would you recommend a creative professional approaching an attorney and sitting down for the first time and being able to manage the relationship from the sense of, I don't want to get into a huge cost situation where I'm just spending money over money doing this. How do I get what I need? And I don't want to say the least amount of money, because this is really important. You're not buying a used car. You're really not. But how do you manage the relationship with the cost? How do you communicate that with clients for the first time?
It's funny because these issues we're talking about in the context of design professionals, we also deal with as attorneys, where we're speaking with new clients, new prospective clients. We're trying to understand their business. We're trying to understand what their issues are, what their risks are, and try to come up with a solution for them. And we often get asked, how much is this going to cost? Is this guaranteed? And of course, the answer is always no. In terms of, a litigation matter or some type of dispute. Obviously, no contract we draft can ever be deemed to always be perfect and never create any issues. There's always the possibility of that. But yeah, I think we want to do the same thing that the listeners want to do, which is simply understand the business, price it fairly, and basically, we sell units of our time as attorneys. We bill generally in 1/10 of an hour increments, and we're in the business of selling, access to our legal minds and our legal services. And I think it's just so critical to really understand what the client's true issues are, what the most likely friction points would be in their dealings with their customers, their dealings with their other third parties, and helping them, come up with solutions for those problems. Most attorneys are flexible. We want to help people. We don't want to see people get dragged into courts or have their reputations dragged through the mud or have to pay damages, or the types of issues that this judge case illustrate. And I think that lawyers, most lawyers are willing to have a dialogue and to, if there's fee sensitivity, come up with solutions for that as well. And maybe they don't need everything that we could offer, right? Maybe they just need help on, a rider to an existing contract. Maybe they need help analyzing a new law and understanding how that could implicate their contracts and maybe just tweaking it a little bit. It's not a whole rewrite. It's simply just some suggested additions, some changes based on new circumstances. So, it just comes down to communication. You hit the nail on the head earlier. This stuff is not really that complicated. It's just about thinking about it, allocating risks, allocating rights and responsibilities. So everyone feels like they're getting a fair deal. So no one thinks they're getting taken advantage of or they're exposing themselves to risks that they didn't anticipate. From a drafting standpoint with contracts, any type of commercial dealing, it's just really answering the core questions, right? What are we providing? What's it going to cost? And what are some of the circumstances that could change that? And if that happens, how do you allocate the risks and who's paying what? A good contract does those things. It answers questions that haven't yet been raised, but might be raised in the future. That way you don't go to court and have to fight over it. The worse the contract is, the more likely you're going to be fighting in a courtroom and paying probably much higher legal fees than you would if you simply did the work on the front end. The old saying about the ounce of prevention and the pound of the cure, is applicable to the situation as well. It's really important to be thoughtful about what you're doing, especially when you're in someone's home, doing work to where they raise their family, where they live, something that's very personal to them, and just making sure it's all squared away in a contract that makes sense. It's not full of contradictions, unanswered questions, and issues that are not really fully resolved.
Yeah, and if I can add to that, Josh, I think, Andrew hit the nail on the head. We try to be as accessible as we can. I think the first thing that, whoever you go to seek legal advice from is going to ask for a copy of your current contract. And then what, Andrew and I both do is say, hey, let's hop on a call. I haven't redlined, I haven't rewritten your contract yet. Let's hop on a call and help me understand your business and then what problems you're having. And a lot of times those problems, when you're looking at the contract, start to make sense. I mean, they don't look like they're coming out of nowhere. But that can really dictate whether it's a let's amend this contract or let's start from the ground up would be our recommendation. I think seeing what you have currently and then just a short discussion about your business and its issues really informs what's needed, if anything, because in a lot of instances, there's plenty of design professionals or contractors or clients that reach out to me and they're doing a bang up job. I can add, provisions or clauses they didn't realize that existed and strengthen their business. But for the most part, 95% of the contract doesn't need to change. We're going to tweak and we're going to update, but we're going to send it back out. And then sometimes, you do see something that comes in and you think, yeah, this could use a little bit more time. But either way, I know Andrew and I are upfront about that on that call so that the client isn't our client isn't blindsided with that, the work that we do afterwards. So I think being comfortable to sit your contract, sit on that initial call is really valuable in helping you see what the next step should be.
It's so funny. My intent was to cover so much more today than I was able to throw at you. But the responses, I think what we got today was absolute gold. One of the things that I wanted to ask you about were two other cases. And I know that you don't specialize in IP per se, again, but There was a case, Gifford v. Shield, which I've been covering a lot, which has to do with aesthetic copying in social media. And we can put a pin in that one. But I did want your take on one other thing, the Donald Judd Foundation v. Clements and Kim Kardashian for a dupe of the La Manzana table in the Chair 84 that Donald Judd created, which wound up in a Kim Kardashian Skims office and on a video for AD that was seen by something like 7 million people before it was taken down or had 7 million views. And I think the reason I'm bringing it up is because it came back to the contract, and I'm paraphrasing this, but in the contract from Clements to Kardashian, it said something to the effect of, in the style of would be created, and then it wound up being almost verbatim. And that case too is working its way through the courts. And the reason I bring it up is because it comes back to the contract. It comes back to the verbiage and the text and the idea and the communications that are espoused in the contracts and how important those ideas are. You can't just throw in a friends and family type offer. You can't throw in an in the style of and not have that. You're kind of at the whim and will of a jury and a judge, are you not?
Yeah, I mean, that seems like a classic ambiguous term in a contract, right? Where you read it and it's a little unclear. That can mean different things to different people depending on the context. And anytime a contract is vague or abstract in its definitions, especially the central purpose of the contract to create something, but without detail other than in the style of, I think is probably a much increased possibility and risk of litigation or claims over that. So to your point as to the initial contract, that you probably want a little bit more than that in terms of what you're actually getting for the contract price. I think, and obviously that case, I know we talked about that briefly recently, Josh, could have huge ramifications in the world of intellectual property law, in the world of how one holds themselves out and the type of product that they create, their design choices and their ability to, be inspired by other designers, their ability to look to other designs and sort of take it and then put a twist on it. It'll be interesting to see how that plays out. But from a contract standpoint, I would be concerned with just the general vagueness of the descriptor there.
Very cool. And with that, listen, isn't it fascinating how fast an hour can go by?
When you're having fun, yeah.
Exactly. Exactly. Listen, guys, I really, Andrew, Carter, I greatly appreciate you guys doing this. And I would love it if maybe we could circle back, especially as this particular case, Judge v. Drew Designs sort of winds its way through the courts, because I know that there's a lot of folks in the industry watching and learning from this, which I think there's a positive for that. So if we could circle back and as we get through this, come back and rediscuss, I'd love that.
Yeah, we'd love to come back, Josh. And for the listeners, Josh found us through an article that we put out through our website. If you simply Google our names, Andrew McBride, Carter Pope, with Adams and Reese, it's available on our online bios. It has more information as sort of some takeaways from this case and what potentially got the contractor or the designer in this case in trouble, and maybe what could be done differently in the future. We would invite you to take a look at that, and Josh would be happy to come back and update you on what changes or talk about other issues as well. We've certainly appreciated being on today.
Absolutely. And I love that. And you know what, let me make it easy for everyone. Per usual, go to the show notes and there will be a link to both the website and the article that was published, so you can read it for yourselves, because it was really, really good.
Excellent. Thank you, Josh.
Thanks, Josh.
Thank you, Andrew and Carter. Enlightening. Thank you to my incredible partner sponsors, TimberTech, Pacific Sales, and Design Hardware. Amazing companies and great friends to the trade, so please give them an opportunity for your next project. Thank you for listening, subscribing to the show, and sharing with your colleagues. If not already subscribing, please consider doing so that you receive every new episode automatically to your podcast feed. Please keep those emails coming, convobydesign@outlook.com, and follow the conversation on Instagram @convobydesign with an X. Until next week, Thank you for sharing this time together. And listen, until the next episode, be well, stay focused, and now that it's arrived in earnest, try to rise above the chaos.